I do not choose to be a common man. I seek opportunity, not security. I do not wish to be kept citizen, humbled and dulled by having the state look after me. I want to take the calculated risk, to dream and to build, to fall and to succeed. I refuse to barter incentive for a dole. I prefer the challenges of life to the guaranteed existence, the thrill of fulfillment, to the stalled calm of utopia. I will not trade freedom for benefits, nor my dignity for a handout. I will never cower before any master, nor bend to any threat. It is my heritage to start erect, proud and unafraid, to think and act for myself, to enjoy the benefit of creations, and to face the world boldly and say, this, with God's help, I have done. All this is what it means to be an entrepreneur. This poem was written in 1776, literally, by Thomas Paine. And it's basically coined, I will not be a common man. Most of us that are just now joining, I appreciate you guys. This is the Supreme Decisions Legal Minute podcast, and I am your host, Supreme Decisions. What happens is I'm teaching you or offering you an opportunity to stand up for yourself against a legal system that is actually scaled and working against the common good of law. I've given example after example, over 300 plus videos. This is now podcast, I believe it's 70. And I'm going to continue to give you more as I grow. I'm going to give you more as, my knowledge itself expands, even the practices I take upon. Because everything that I deal with has never been in the majority. Even in school, I did things when people had a high right, I cut my hair into a high left. They run to the barbershop and get their cuts. I actually cut my own hair. I was very skilled at it. Wouldn't say very good, but I was very skilled at it because I took comfort and pride in knowing I did it. I didn't have to wait on anyone else to do it. I actually ventured from Georgia into a existence that was 1,500 miles from my closest relative and created a life for myself. I later then built something that was not only for me, but for those that are behind me. I've offered opportunities to help those grow in their own ventures. But at the end of the day, the whole existence or my whole purpose has been to empower others to not only stand on their own, but to be able to pass on the things that are not theirs to keep. The knowledge I have is not my knowledge. The lessons I give are not my lessons. These are things that I have learned from others. And giving that, it sets me in a place of not being a common man. When you decide to stand up for yourself in a legal system that is slated against the law, you are no longer a common man or woman. You are no longer a common being because you're in the minority. 95% of people go with the flow because they understand that the system is slated against them and they'd rather not fight. It's called an adversarial system for a reason. It requires the one thing that you are given by God, and that's the right for confrontation. Yet, we're slated and believed and programmed to even resist confrontation. even those that are confrontational, they're programmed to believe that the system is too big to fight back against. And I hearken against the one thing, because like, again, I often give you references that I know that are easiest for me because I learned from Abraham Lincoln. Keep it so simple even a child can understand. So there are childlike qualities that I have, and one of those is hearkening to Marvel movies. I grew up on Wonder Woman. I grew up on Superman. I grew up on Batman. These are things that I can relate to. Wonder Woman, even in the newer movie, was fixated on something that she referred to as a God killer. Many of us look at our fight back as the paperwork being the God killer, when Wonder Woman thought something else was the God killer, looking externally for something to create her ability to win. In her mind, something else offered her the win. And in a lot of our minds, we think the paperwork is what offers us the opportunity to win. She was laughed at. The deity that she referred to told her, you are the God killer. It's not something external. When I spoke of someone, the public, being the strongest and most powerful person in the courtroom, I had someone come at me. I actually have often people come at me because I say this. Yet, of those that fight back, almost 80% of those people win. Those that fight back, almost 80% of those people win. Because it's not the paperwork that's winning. Everything that they're looking for is inside of them because they are not a common man. Today, what I'm going to deal with is something simple. Because it requires you not to be a common man or woman, but it also requires you to not to be easily moved. Because you know they're going to lie to you. You know they're going to tell you things that they can't do. They are going to put pressure on you and even those that are around you in order to force you to become something that you are not or don't want to be. We also know that the pen is mightier than the sword. Why? Because any right that is exercised, whether it's given up or exercised, must be done in writing. You must put pen to paper. Even in something called the confrontation clause. Because that's one restriction that the government does not have, which makes the people more powerful, because it offers the people the right to confront their accusers. It offers the people that are the right to confront the accusations against them. You have a choice. We talked about the prosecutor cherry picking cases. You know, the fallible system with human beings who have the right or the will to choose. They have a right to choose. We also have to have the right to confront that choice. Why? Because it deals with the person that they are accusing, which is why a third party cannot fight for you, which is why paperwork cannot fight for you. The paperwork is only a precursor. I refer to even a citation as a contract to fight. Because most of us don't have any clue of something that I actually dealt with, which is basically Crawford v. Washington, 541 U.S. 36, and this is a 2004 case. Crawford held an admission of Testimonial hearsay violates the Sixth Amendment confrontation clause because you have a right to face your accuser. And anytime you are not allotted that right by the person who made a conscious choice to take on that allegation, that's a violation of your rights. That's a violation of due process. Because all of this is a show. It's horrible theater for the most part. Because you have a lot of actors that are involved in this, but only one person that is suffering repercussions from the actions of these actors. And in doing so, you have the right to exercise. The purpose of the confrontation is to make sure no one just says anything. Why? Because even when you're dealing with human rights, everyone has the right to a clean reputation. It's been spoken about since the beginning of time. It's spoken about in the Bible several times. You hear gangsters talking about keep your face card clean. You heard Abraham Lincoln give it in a speech. You heard Martin Luther King talk about it. Understanding the importance of your reputation. When I spoke about the killing of Kenneth Chamberlain Sr., the reputation that the police officers had and exercised and showed was that they were liars. They showed that they were violent against the public. They showed that they were not to be trusted. And even in Scarface, again, the police committed more crimes than the actual criminals. Why? Because they had a choice. They exercised their own willpower to do something that violated this man's civil liberties. They violated due process. Because even with them, prior to being fired, their words was used as an amicus brief. Why? Because they're the experts on law, yet the allowing of testimonial hearsay, which was their police reports without supporting evidence, was a violation of law, which is why they are in federal court right now being sued for millions. These are the examples that I speak of. This is just one. This is also to re-reference. Sometimes you have to listen to more than one conversation to understand the context of what's being spoken. Understand that there are directions. There are levels to this, as some people say. But even in the aspects of this, when we're talking about putting a police officer's character on trial, confronting the evidence, because again, hearsay is something said that is not supported by evidence. Something presented that is not supported by evidence. Probable cause can't even be there unless there is evidence of a crime. So the reason of the importance of the conversation that we're having and evidence is simple. It is the pretext of all due process beginnings. Because procedural guarantees of the confrontational clause or the confrontation clause is based solely in evidence, because that's what the jury has to deliberate. That is what goes back and they have to make a decision on. But a lot of times we have these things that are given. And then you have, just to give you a great idea, I spoke about the Jussie Smollett incident in Chicago where the police officers did a lot of lying on their behalf. Jussie Smollett was pretty much found to be staging some stuff, and Chicago police wanted $130,000 from Jussie Smollett. And I even spoke about the multitude of violations that these exact same officers had done prior to the Smollett, and these exact same governor and police chief who are now both fired because one, the police chief was found to be lying about a report of him being drunk on the job. And first he did it, then he didn't do it, then he was medicated. But again, he supported lying from other officers. And how they chose not to show the exact same repercussions to the citizens that they had violated. Yet they wanted a citizen that they felt had violated them to pay. They wanted someone else to do something that they were not, who are supposed to be in a position of servitude, to do that they were unwilling to do. And now, whenever you look at his trial, the trial of Jussie Smollett, or Juicy in this case, Juicy Smouye, his conviction was immediately filed for appeal. It was filed for appeal due to legal error. The legal error was the simple fact that they still didn't have any evidence against Jussie Smollett to come through that conviction. So now going through the process, understanding the pressures, even in the Kyle Rittenhouse case, there were several points of evidence that were not presented, which led to his not guilty verdict. A lot of people were upset about that. The problem is understanding the legalese that are going on, understanding the show that's being put on, and understanding the fact that disregarding, ignoring, or not presenting certain evidence allows for things such as this. But also remembering, prosecutors lose almost 80% of the time they go to trial. Prosecutors lose almost 80% of the time they go to trial, which is why they pick and choose and look for weaknesses. They look for the common man. They look for the common woman. That's why I began this show with, I am not a common man. And those of you that are listening to me, you are not a common person. You are not a common human being. You probably heard that throughout your life. I want you to understand that. Understanding not being common, not being like the masses, not being like everybody else, not caring about being like everyone else. Because when you're walking outside the norms, you become the problem. When you're the ones that are asserting your authority, understanding there are no servant that has power over you. Why? Because they are serving you. The prosecutor, I'm speaking for the people. Guess who the people? You are the people. The judge is making decisions based on the masses of the people. Guess who the people are? You. The defense attorney, who does they work for? Because if they don't do what you ask them to do as an employee, why? Because you're the one cutting the check for them. Who are they working for? You. So if the prosecutor, defense, and the judge are all speaking for the people, and you are the people, who's the most powerful person in the court? Sometimes I allow that for dramatic effect because I want you to understand. Everything that I do is to actually push you forward and make you question the things that you are being told. Because I didn't say anything that was out of line. I didn't say anything that wasn't your fault if you're not getting the things that you want. One of my favorite movies is V for Vendetta. And in the movie, there was a speech where he took over the radio station. And V spoke about the ills of the government and the horrible acts of the chancellor. And he said, if you're looking for someone to blame, you need not look any further than the mirror. If you're upset with the actions that are being taken forward in your community, it's your fault. If you are displeased with the way you're being policed, it's your fault. And here's how. There are these things called elections. A lot of us believe that they're rigged, and guess what? I'm one of those people. However, if you don't participate, you can't have a say-so in it. He who has the vote has the power. And when you look at a population that have the ability to vote, and you look at the percentages of being around 30% of those people that have the ability to vote that are voting, that means 70% of people decided that they're not going to participate. And in that 70%, those are the ones who had the greatest opinion. Why is that? They want to complain. They need you to be in that hole with them. I'm actually going to do a different show on a different channel about that. Because a lot of people don't want the change because they don't see the change. They rather not see the change because if that change is seen, that means they have to be different. You are the one that choose the district attorneys. You are the one that choose the sheriffs. You are the one that choose the judges. You can't then complain about the actions of those choices that you made. Here's the greater part. If you didn't vote, you don't even have a conversation to be had because you didn't exercise. You didn't make a choice. Now, when you got in that ticket, you chose to not fight. When you got beat up by the cops, what did you do? You made a complaint to the cops about the cops, thinking that the cops, who you say are bad, are going to reprimand the cop. Oh, wait a minute. Didn't we talk about the blue shield? Aren't they bad? So I'm going to complain to a cop about a cop, but I'm not going to do anything about it. Yet, I want something done about it. The definition of insanity is doing the same thing over and over again and expecting something different. Many of us go through life and do that. We get up every morning, go to our job. We come home after we get off work. We sit down, eat our food, watch a couple of TV shows, but yet we're expecting something different. We're expecting something greater to come from exactly doing the same thing every day, day in, day out, and nothing changing. If you don't change, nothing around you changes. You cannot grow sitting in the same space. You cannot be an uncommon man or woman and remain common. That is why I speak of not being a common man. when you're asking for this evidence. Understand, that's what you're supposed to do. You are supposed to do. These are the blueprints of giving you your ability to fight back. These are the blueprints of giving you direction. If you're choosing not to accept the guidance, that's your fault too. Because one thing about this country is it allows you to deflect responsibility. I talk to people often that it's always somebody else's fault. It's the cop's fault. It's the DA's fault. It's the judge's fault. What about you? Because when I asked them, did you do this? Did you do that? All of them say no. No. I just let it happen. Guess what? You made the decision to allow it to happen. Because it's not our darkness that we fear the most. It is our light. This is something I gave you 2 years ago. I'm going to say that. It is not our darkness. It is our light. And I guarantee that poem is older than me. Yet, we're making a choice not to follow through. We're making a choice to give somebody else the opportunity to control our lives, which is why I love the part of this poem that states, I'm not going to allow the state to dictate to me. I'm not going to be a beneficiary of the state. I'm not going to let the state choose what it is that's good for me. Why? Because I have the ability and mental capacity and the wherewithal to be uncommon. I don't have to just go along just to not be confronted. I can take the confrontation and give you a reasonable answer. That's the great part about I can give you an answer of my own decision. Why? Because it's mine. It is something I believe. It's something I can stand on, which is why there has to be an evidence when we're talking about hearsay. When we're talking about testimony, there has to be evidence. That's why this is the most important part. This is the foundation. If you're building a house, it has to be built on evidence. Because evidence is the core piece of any confrontation. Because most of you people have no idea. I did a video, I want to say in 2018. I spoke about do this first. The first thing that anybody files is a motion for discovery. Why? Because you're asking or demanding, which is what a motion does, for the evidence against you. You're confronting the DA about the evidence against you. Now, just like I spoke about in the Jesse Smollett, the legal error. If there is no evidence sufficient to support a conviction, you're allowed an appeal. You're allowed to overturn that conviction. Guess what judges don't like? One is a lot of appeals. They also don't like their decisions being overturned. Why? Because they also have judicial discretion. Because a judge doesn't even have to listen to the decision of the jury. They don't have to listen to the recommendations on deals. You know, the plea bargains. They're making a conscious decision on everything they do, but it depends on if you're fighting back. Because most people don't even know prior to going to prison, you have to convict yourself. You're asked 3 questions and you must answer yes to all 3, which is why the state can't apologize. You are then asked after in your, what do you call that? When you're just set to get out, they're asking you to allocute. Can you allocute to your crime? Why? Because if you allocute to it, you can no longer sue them because you're telling them they did the right thing. Because they can't accept being wrong. Because you have to accept responsibility for it. And then you offer someone else the opportunity to decide on if you're deserving of something that they can't give you. I'm going to say that one more time. You offer someone else an opportunity to decide if you're deserving of something that they can't give you. But in doing that, the risk of prosecutorial abuse when government officers are involved in the production of testimonial with an eye towards trial, involved in the production of testimony prior to trial. Because what happens is, when you're doing your motion, requesting the evidence, the prosecution, who cherry picks your case, because they're trying to see if you're the common man or woman, has an opportunity to make a decision whether to move forward or not. Because if there is no evidence, they don't move forward or shouldn't move forward. But if they do, they open themselves up for liability, personal and stately for the most part. Because you can actually sue the state if the prosecution makes a willful decision to violate your due process. Which is why the state's attorney general is the one who makes the decision on what evidence they decide not to turn over. And the state's attorney general is the one that actually makes the decision, not the DA. Now, in Davis v. Washington 126 in 2006, only testimonial statements are subject to confrontational clause, and nothing computer generated is. Now, here's where it gets kind of sticky. Because if they're saying the computer generates it, not that a person types this in, but the person typing it in, you can cross-examine. Why? Because they're the one putting in the information. But if it's on a computer, it's pretty much, because of the Patriot Act, there for life, even if there's a mistake. That's why you have to go to the fallible portion of it, the human portion of it. Even though we offer the infallibility of humans with police officers, we offer the opportunity of infallibility with prosecutors. Because we say when we put you in an orange jumpsuit, you did it. You are a criminal. They actually tell you that. You are an ex-con. I actually watched a couple videos lately where they talked about this man going to jail 10 years ago. I hear people say, oh, I've exposed him, because they put up the fact that I've gone to jail multiple times. Yet they don't tell you about the non-convictions. Why is that? I'm still an ex-con, even though I haven't been convicted. How'd that work? I've been in an orange jumpsuit several times. I've been to court several times. Thank you, DeKalb County. And I've also had my rights violated on a multitude of levels. From the cops, DeKalb County again, the prosecutors, John Melvin, even a few judges. Because even my first instance with DeKalb County, I had a conviction. Well, actually, I had a, what do you call that? I had a incident where I got into a little skirmish, and I went and pled guilty because it happened. I was on video. It wasn't really a whole lot I could talk about. Yes, I did it. It was on video. Well, the officer that arrested me, that was actually there on the scene, that witnessed everything, was not there in court. So there was this fat officer, and I'm actually describing him correctly, but this officer was sitting there. I'm sitting there with my father and my girlfriend at the time. I had explained to my father what had happened. My father was there to kind of, I guess, be like a witness on my behalf, and like, yeah, I'm going to take him into my custody. This was going to happen by me pleading guilty because, one, like I said, I did it. Well, this cop stands up and begins to read off something that wasn't even in the police report. And it was a flat out lie. So as soon as he started, I spoke up. I said, oh, whoa, I didn't do that. I'm not sure what he's doing. That's not me. The judge stops me. Are you changing your plea? No, I'm not changing my plea. I've already pled guilty. Yes, I did what I'm charged with. I don't know what that is that he's talking about. So the judge says, well, let him finish. Okay, as long as he stops lying. The officer then continues to lie. I stop him a second time. Like, hey, man, that's not me. Not sure what you're doing, but we're not going to have that on me. I did what I did. I'm not taking blame for some other shit. The judge then tells me, if you interrupt him again, you're going to have to change your plea. My response is, I'm not changing my plea. I did do what I am charged with. What he's talking about has nothing to do with what I am charged with. He is either mistaken or he's lying. I turn around, my father is looking at me crazy. Why? Because he was programmed to believe that the police, because I was in cuffs, because I had pled guilty to something, that this officer was telling the truth, and I just didn't want my father to hear it. That was what he took from that confrontation. The officer then goes into a third line of questioning. I said, man, F this. Forget, I'm not doing this. So the judge stops. In the middle of the conversation between myself and the judge, the officer that arrested me walks in. All 5'3", 110 pounds of woman walks in. And the judge asks, who are you? She yells out, I'm the arresting officer and I have the video. I apologize for being late. She had the evidence. She plays the video of the skirmish. Had nothing to do with what that officer was talking about. I turn around, look at the judge and the officer and say, thank you. The judge dropped my charges because the officer had lied. Had I not spoke up, had I not been an uncommon man at that point, there could have been other things that happened. Had I chose to not continue to not allow a malfeasance against me, even the protection of my horrible reputation. Yeah, I did some messed up stuff. I didn't do that. Yes, I've done a lot of screwed up things. I didn't do that. When the evidence was presented, because of the hearsay of this officer, it was contradictory, which we find out oftentimes, even in the killing of Kenneth Chamberlain Sr. These officers who use stock language, who I also spoke about, often give limited or misleading testimony to prosecutors. See where I'm going with this? If the prosecutor makes a conscious choice to move forward without proper evidence and you allow it, it's your fault. If they do it, they are liable for it. If you fight, are you a common man or are you not a common man? That's your choice too. And just to give you another example, there was a video that it was amazing to me how a DA was just like the police were right, the police were right, the police were right, the police were right. None of these police officers had body cameras on, which was actually required and codified in their department policy and also state statute. None of them had it. Over 20 officers. Now, I spoke about 3 individuals because it literally happened. All of them happened within like a week. In a week's time, the police officers killed 3 people, all of them with pretty much the same context of it. Well, in this particular case, the DA got on TV, had a press conference. Actually, he also stood in court. He used stock language that worked in his favor because most of us know when a police officer gets out of the car, they walk up to your vehicle, conveyance, whatever, they touch it. The DA used his vehicle came in contact with several police officers. Now, is that a lie? Absolutely. But not technically. Yes, the conversation he was having because he was painting a picture. These people did not have a body camera on. They came in contact with this car while it was in motion. Therefore, they shot. What they didn't realize at the time of him saying this BS was there was a video down the street. People had a Ring doorbell that caught the entire incident. Yes, the police officers did come in contact with the vehicle prior to them shooting. The contact was them reaching out to come in contact with the car, not that the car was being driven towards them. I'm going to say that one more time. It was the police officers' actions of placing themselves in a position to contact the car. They were actually reaching out to touch it. Now, doesn't that change the picture a little bit? Or does it change the picture a lot? The simple fact that it was stated that he made contact, the police officers made contact prior to the shooting, was an inference in which the prosecutor was trying to paint the picture of the car was being used as a weapon against police officers, when in fact, he was eluding, which under Tennessee v. Gardner does not allow them to shoot him because he has to be using something other than the car as a weapon. Has to be using something other than the car as a weapon. And there was no weapon found on this person. And the whole purpose of them executing this warrant was that there was drugs on the premises, like Breonna Taylor, which no drugs were found, which is why within months, several $1 million settlements were made to kind of quiet that incident. And the fact that they did not fire all of the officers involved, just one. They didn't charge all the officers involved, just one. And when we look at these things, once the video was turned over, body cam footage appeared, and all of a sudden we heard nothing else about the case. Why is that? Because, again, the evidence contradicts the narrative. It contradicted the stock language that was used by police officers who don't turn over all of the evidence, who at the time, the prosecution admitted he didn't have the body camera footage. Yet he chose to prosecute. There was a judge that signed off on a warrant without probable cause. And yet, now the video contradicts everything that everybody said and did. We hear nothing about it. But you know what else is funny? Who all's still fighting? You see this happen over and over and over and over and over and over and over. And all of a sudden, it seems like the bad apples are the police. Not necessarily the persons that are police officers, but the means of policing. Because oftentimes we talk about the improperness of training. I talk about and have shown, and I actually have another podcast. The podcast on next week, you're actually going to be able to hear me give you the complete connotation of they're being policed based on revenue generation, quotas. And I actually did one last week. Quotas. Because if I'm policing on a quota, am I policing based on lawfulness or unlawfulness? Because that's the whole context of me breaking the law, right? That there's something unlawful going on. I'm coming into the courts as an expert on law. But if I'm not dealing with law, am I really dealing with what's going on? Now, here's the greater part. I say these things. A lot of people hate when I say it. I get it. Sometimes I don't like it. But you know what doesn't change? The Supreme Court cases. Because I can give you, my feelings, my beliefs, my ideas. Doesn't change the Supreme Court cases. And here's a great one. Well, he's been to jail. Didn't change Terry v. Ohio one bit. He was charged with RICO, racketeering. Didn't change Crawford v. Washington. Not one iota. And Davis v. Washington is still on the books. Still sets a precedent that has to be followed. Hasn't changed the Constitution one bit. Yet, these are the things that people want you to hear instead of the actual application of the truth. Because the one thing I do understand is I'm not a common man. And as the poem said, I choose not to be a common man. Because we can look at a multitude of things and see there are things where we all come up and the programming kind of sets in. But at the end of the day, we still need to figure out it's our choice. We can demand the evidence so we can confront those that are saying things against us. We can choose to protect our reputation. But it's just like the art of war. It's choosing the battles you want. And I think that, for me, is the most difficult thing because we are emotional. The law isn't. The law doesn't care one way or another. And understanding comes when you have an opportunity to get just to have the opportunity to inject reason into your decision making. And the saddest part about that is most people aren't trained or programmed or any of that thing that we like to say to do that. But let me give you an idea, because the court defines a statement as an oral or written assertion. An oral or written assertion, such as an affidavit. That's a statement. Doesn't say testimony. Because we have the right to remain silent. And you often hear me say nobody cares about the side of the defendant. Because at the end of the day, the defendant's side is emotional because you're trying to tell them something. Law only cares if the violation of due process or the act of due process was exercised. Your side has nothing to do with due process. Because in fact, you don't have to offer an alibi. Why? Because you have the right to remain silent. Florida v. Royer, you don't even have to participate in a police investigation. Why? Because you have the right to remain silent. And you hear this more often than not. Anything you say can and will be held against you. Notice it doesn't say will be used for you or will be used in the court of law. It will be held against you. What happens when the rabbit has a gun? Because if we're going to view the prosecutor and the police as predators, we're going to view ourselves as prey. What happens when the prey has a gun? What happens when everything a police officer says can and will be held against them? What happens when everything a prosecutor says and does will be held against them? What happens when things become uncommon? Do we have actual policing versus revenue generation? Because even coming up, you're going to hear and see me talk about a multitude of things that deal with actual law, that deal with the practice of doing things the right way. Going to deal with police can and can't do. You're going to deal with third parties and their actions, because you even seen a video that I did that talked about security guards. Matter of fact, there's a podcast that I talked about the abilities of the powers of a security guard, which is none. They're citizens. So in fact, since they're employees, they have even less power than citizens. But understanding that, because they too believe that they're police officers, when in fact, just touching you, which we're seeing as a result for most people in stores, because most people had no idea that theft, until people started fighting back against it, was a civil act and not a criminal one, unless it became something where there is damage or an exorbitant amount of financial risk, which is why most states have it to where if you're stealing above a certain number, that's when it becomes larceny. That's when it becomes a criminal act, because there's an intent. Because to go in and take a pair of socks, there's no intent in that. To go in and take 10 boxes of socks, you had to do some planning. You had to do some thinking. So understanding there are levels, there are differences, and understanding those things is what I'm here for. Now, the court defines a statement, part 2, is a nonverbal conduct of a person if it is intended as an assertion. The police officer's report contains the officer's version of events. One of the things that you can do is challenge the accuracy of stock language, because it's giving a version in stock language which does not allow for specifics, doesn't go into specificity, which as a servant they must be. Under law, they must be. But again, if we don't challenge that, it's our fault. And if those involved in things such as the witness list, when you're doing discovery, so you can actually set up something, even the greatest part is a character. You can actually go after the character. Why? Because that allows, just like I said, the police officer's character on trial, that allows for a picture to be painted. Because just like I had told you before, one lie can destroy 100 truths. One lie can destroy 100 truths. So whenever you have a police officer that has been challenged, as I spoke about last week, in the statements that he's made, guess what? That now, if they're found to be untrue at any point, because you can't be really truthful in stock language, if it's found to be untrue at any point, all the actions of that police officer can now be drawn into question for past and present cases. Understand that. They go retroactive. So just like everyone that was involved with the police officer that had planted drugs on someone 400 plus times, every case that he's involved in is now brought into question. Every officer that you are pressing, it forces not only that officer to do something different, it forces them as a system to do something different. Because now the training that we require of them has to take place, because if not, this entire system as a whole begins to suffer. Why? Because we're beginning to exercise and demand our due process. Now, I talked briefly about chain of custody. I'll get into that deeper later because, again, each one of these steps offer you something magnanimous. Look it up. But even something as small as if those involved in the chain of custody are not on the prosecutor's witness list, you can subpoena them. You can place them as part of your defensive strategy because that's part of the due process. One of the things that I did in my RICO trial, which was actually funny, there was a reporter who did like a ton of stories and said things that she had looked up everything and she knew this and she knew that. She said it with definitiveness. She interviewed the prosecutor. I thought it was actually hilarious. So as a defensive strategy, I placed both of them on my witness list and I subpoenaed both of them. What happens is now, did I enforce it? No. But it made them think. It offered me a buffer because they can talk about something. They can paint a different picture. Why? Because it's their picture. I took two of their brushes away. What you have to understand is you can actually weaponize the things that they want and create something that's greater in advantage to you. Everything that you do must have a point and a purpose. Everything that you say, every question you ask, it has to be supported with evidence. And you also must point out the lack thereof. Because at this point, this isn't checkers. This game is chess. Because allowing emotions or hearsay evidence can be detrimental not only to your case, but to everyone's case. And you have to understand the burden of proof for conviction rests solely with the prosecution. Because you have to also understand everyone is presumed to know law once you hit the age of 18 because you're no longer a child. Children under 7 are presumed to be incapable of committing a crime unless when you're looking at evidence, opinions don't matter. Unless you can bring up proof of that opinion, which will be done through an expert. But you can always challenge the expert on the facts of your particular case. Character and reputation don't matter unless you can point out that someone has been untruthful before. Hearsay doesn't matter if it's not supported. Documentary evidence. Remember, the computer-generated evidence. You can't really challenge that. However, you can challenge the author of that evidence. Copies. One of the things that you're going to often get are copies. Pay attention to that. Because there are only a couple of reasons why copies can be available and admitted in the court. And one of those is that you allow it. Because all of this rests with you. And be sure every record of evidence that you obtain is actually official. Because they have people they have to answer to. They have things they have to answer for. And if they don't have those answers, that's advantage to you. But you also have to know what you're asking for or what's supposed to be there. And understand prosecutorial strategies of death by 1,000 paper cuts, where they give you so much evidence and hearsay and documents till they hope you don't even have any clue what you're looking for or at. That's what this is now going to turn into. Because when I talk about weaponizing your defense, I'm authorizing you to have the ability to be free, to live free, to speak free, to act free. I want to thank you guys for listening. Don't forget to support the podcast. There will be a link somewhere. I'm going to have polls and questions that are posed for you guys that are watching online. Don't forget to participate in those polls. Don't forget, join the channel. Going to start having the masterclass put up. It's going to be something separate, and it's going to be special. Each episode is going to get deeper into something that you should be doing and how you can actually become greater at doing on your own. You have the opportunity of not being a common man if you choose. Supreme, out.